Good evening, everyone. My name is Kolawole Abiri. First, I want to apologize for the disruptions in the course of initial presentation. I didn't know what was going on, but I have the second chance to present. I hope I will make it as real as possible. Yes, I will be talking on litigating common problem, actors' perspectives in sharing climate litigation. I'm a PhD candidate at Dalhousie University. This is my first research year, and I hope I'll be able to share a few of what I've learned in the course of my preliminary research. Now, the topic is such interesting to me because of the fact that I've been involved in litigation as a lawyer for some time, and I'm looking at litigation initially from the perspective of a professional, different from the perspective of scholars, and I've come to realize that there are certain things that scholars find very interesting, very exciting, that the professionals in practice on the field see as boring, as unnecessary, technical, or theoretical. Now, why do I feel that climate litigation is such an area that I should consider as a researcher? First and foremost is to be able to connect the practical experience on the field with what is going on in the field of theory, as well as to deepen my knowledge. Now, I'm starting with what's the meaning of climate litigation, although I found that it's been a very difficult topic to define, and the few definitions have come across a point to one central point, that is where we have cases, lawsuits, adjudication process in which the central issue is about climate change, either about mitigation efforts, about adaptation, or loss and damage. Now, the further classifications for the purpose of clarification is what do we look at when we are considering the climate litigations? What are the things that should be of concern to us? And I came across this, which is of interest, the classification that was made in 2010, that litigation is such that either promotes certain objective or regulatory approach to solving the problem of climate change, or such that is defensive, trying to protect the status quo. And the other one is about boundary testing, when we have either regulatory provisions or legislative provisions that have been hotly contested, and litigations are resulted into by disputants, by different parties, to have a clear understanding of the applications of those provisions, either for the purpose of application, for the purpose of planning. And then we also have the classification that consider litigation from the perspective of either perfecting certain interest. And I look at it either from the perspective of public law or private law. If it's public law, we can be looking at climate litigation from a constitutional law, interpretations of the Constitution, from administrative law, environmental law, then the climate law itself. We can also look at a criminal law, for instance, in some cases of negligence or nuisance, such that or statutory responsibility, duty of care that have caused so much damage, not just to individual, but to assets and properties as such, so grievous that criminal law is being invoked. And then we also look at it from the perspective of human rights law, international law, tax law, and consumer protection. That's under public law. And the other aspect is from private law, the tort law, contract law, and property law. Now, why does litigation have to matter to us? Why? Why do we need to consider it? What is the importance of focusing on litigation actors? Why can't we look at the dispute itself? Why can't we be focusing on the law, the regulations, the provision, the charter, the treaty provisions? Why are we being concerned about litigation actors? And I feel that litigation actors are very relevant in the entire discussion. And one of the reasons why we have to look at litigation actors is because of the relational processes that occur within a litigation system. A lot of interaction take place within the litigation system. And the other point that I feel very relevant is displacement of legal institution, of courts or judges from climate governance. I also look at the role of lawyers and experts, particularly the capacity, the experience, and resources. What do they bring to the table when we are having cases that concerns climate change? And then we have the role of mass movement, and which also bring to the table more players in the political arena. As you can see from the picture beside, you could see a young lady, different categories of people of different ages. It's like we're having the past, the present, and the future being represented. Then regulatory capture. Now, this is an area that has interested me as a theory. It's an area that I wasn't really conscious of in the course of my practice, but I discovered it's an area that has generated so much scholarly interest. Why? Because the litigation is as a result of so many interplay that has happened in the past. For instance, it may be because, we are not having enough laws. And why are we not having enough laws? Or we are having laws that are very weak, or we're having laws that are very strong but are not being implemented, or not being properly implemented, or that the implementation and the statute provisions or regulatory provisions, there are disconnects that we begin to wonder what has happened. So from the whole ecosystem of regulatory process, I begin to see why public interest being relegated to the background. Why do we have a situation where private interest dominates or are more feasible than the public interest? Why is it that either all the participants are being captured through one process or the other, through either corruption, compromise, and a situation whereby laws are not being enforced? And then another reason why we need to look at litigation actors is this issue of the role and impasse of factual parties. For instance, the picture again that we see, you have a lot of them that will not be mentioned in any litigation, but decisions of courts will apply to them as if they're parties. And these are people I refer to maybe virtual parties in litigation process. Now, by continuation of why litigation is because of what litigation brings to climate governance, and which are, this list is not exhaustive, but these are telling. One, they said deterrence, regulatory strategies. Litigation is also used as a way of information gathering and dissemination. For instance, through the process of discovery, through this process of interrogatories, a lot of information gatherings take place. And then we have litigation being used as government or corporate accountability measure, and where, for instance, the government agency are not providing necessary account of their stewardship, and then litigation is resorted to seek for that accountability. And then we also see that litigation also bring direct participation in policy making of private individuals. And litigation is also resorted to as a compensatory system or embedded aggregations of people's voices. It's also a means of private or public mobilization of law for public interest, or a means of direct taxation where government is seeking the damages for certain breaches that the government would not have been able to attain either through rulemaking process. Then we need to identify who litigation actors are. And the discussion had always been, who are the litigation actors and what category do they fall into? I start this conversation with the main litigation actor in climate change litigation are courts, judges, because without courts, there's no way we can have the formal process for adjudication process. And the court can be administrative or judicial. It can be domestic or international courts. As some of the speakers have mentioned, some of international tribunals that are being involved in climate change litigations, like International Court of Justice, international tribunals on laws of the sea, heat laws, and other regional bodies. Now, on the state actors, on the actors, we can have state actors. There can be international, national, and subnational. State actors can be independent states at the national, at the international level when they're having international agreement or international dispute. For instance, we now have the state of Vanuatu that is seeking for advisory opinion from the ICJ. Or we can also have international institutions. We have national state actors, either federal government, federal agency, or subnational, like states where we have federal system of government or regional system of government. Like in my country, Nigeria, we have 36 states, can be state actors against the federal government, which is the national actors in litigation process. And then as against the state actors, we can also have non-state actors. Non-state actors, this is not exclusive representation, exhaustive representation of non-state actors. We have individuals, NGOs, and lawyers, and we also have corporations as non-state actors. We can have public interest actors. Now, public interest actors can be state actors. Public interest actors can also be non-state actors, interestingly. But we need to begin to look at actors from these different lenses. Public interest actors being interested in presumably interested in regulatory objective through litigation. My paper is really looking at that, how state actors use litigation to achieve regulatory objective, or is public interest actors seeking for interpretations of laws, statutes, or whether certain laws are actually binding or enforceable, and how, to what extent it should be enforced. They can also bring litigation, public interest actors for enforcement, either civil or criminal enforcement, or for standard setting. And then I also look at actors from the perspective of private interest actors, who may be non-state actors, mainly, presumably, and then mostly they go for litigation to seek a compensatory measure for solution to dispute problems and solutions, or for anti-regulatory. Perhaps some of these we have commercial interest actors or companies trying to defend their interests, perhaps against stranded assets because of possible effects of regulatory changes. We also have private interest actors trying to seek for injunctive reliefs from courts or for information gathering. Now, the actors, I'm looking at the actors from these broad divisions. We can look at them from these different angles, just like the one previously mentioned here. And then I said that we can have state and non-state actors, public interests against private interest actors, individuals against group actors or coalitions. We can also have professional actors like lawyers or like experts in litigations, like assessors, like or like judges who are perhaps experts in certain area, as against non-professionals who are in the same litigation system together. We can have parties, real parties, as in physical parties. Like this, we have in this courtroom, we have less than 20 people, but the decision may be having effect on thousands of people. So we have parties who are actors and invisible actors who perhaps may be the one financing the litigation process and have real interest, who will be more impacted in the outcome of litigation. And we have, you can have them as environmental or climate interest actors against commercial interest actors. Now, there's these big questions that we need to, I feel that I need to address, and is the actors' interests and identities. And my research has shown that is the, yes, why I, in the previous slide, it appears that I was clear about who the actors are, where do they belong, whether they belong to a particular group or we have a definitive classification of actors. But I need to make this clarification that no, we may not have that clear identities of actors, because most of the actors have multiple identities. And that's why I'm asking this question. Do the actors' classification provide conclusive pictures of their interest? And I reason that it may not. The answer is for us to see that the actors, the classification actually does not provide conclusive pictures of their interest. And then I'm asking the question whether the actor's identity is permanent, contingent, or relative. And I argue that the actor's identities are not permanent because even the commercial interests are also interested about public interest because they are members of the public. The state actors, they are also private individuals on their own. They will not be state actors permanently. I'm talking of state officials who are the face of state actors. The commercial interests are also private individual. And so I feel that we need to also be looking at those classifications that, yes, we may, for convenience sake, try to classify actors, put them in different baskets, but in actual reality, they cross paths. Why do litigation actors form coalitions? And I am still looking at the lessons we can learn from tobacco litigation, the coalitions of lawyers after waves upon waves of litigation results. And then we now began to have changes. And coalitions I mentioned here occur in a way that is not linear. For instance, I refer to the case of Massachusetts against EPA, in which the petitioner and respondents have mix of different actors. The state on one side with NGOs, and then we have some public interests with some state against another set of states with some commercial interest, having the case being litigated and up to the Supreme Court. Now, I come to these features that has helped me to express and explain this analysis better. First is the whole assumption that litigation is bipolar between two diametrically opposed interests, and that the right and remedies are interdependent, because then the other assumption is that you cannot get more than you are proved, and then that lawsuit is self-contained and only binds the party. That is the doctrines are there. The judgments only bind the parties and does not bind non-parties. And then that part is party initiated and party controlled. And my argument is that climate change litigations have different features. And some of these features do not seem to agree with the whole assumptions of litigation, and which is, it is multidimensional. Why? Because contains multiple and interconnected interests. It's not bipolar. And I also argue that right and remedy are not interdependent because it's in measuring externalities. And I also argue that climate lawsuits are not self-contained, it's diffused and have cascading effects. And then I also argue that, yes, we may argue that court will not frame cases for the parties. The party must initiate the case. But climate change, yes, while party may initiate the case, it's no longer party controlled because of the recognitions of the role of science. It has become very significant to climate change disputes resolution. And then in my conclusion, I argue that actors classifications that I've mentioned now appear theoretical, or because we have a change in power balance and coalitions are being formed, interests are diffused, and it is difficult for us to stick to a particular classifications of climate change actors. In fact, we need to begin to understand the identity, the multiple identity of the climate change actors. We also need to begin to understand what interests they represent. Some private interests may also represent public interest, and while public interests sometimes may represent private interests. Thank you.